When Philip came to Sydney, he did not only come with the first fleet and provisions and convicts and marines, he also came with the foundations of our country. I come now to the institutions. My second point was that the institutions of this country are imbued with Judeo-Christian values. He brought 4 institutions with him: the rule of law, the English language, our Judeo-Christian values, and the crown. And let me begin with the rule of law. It is said by some that New South Wales was a lawless place. It was certainly a penal colony. But Robert Hughes and Malcolm Turnbull have suggested the view that Sydney was in fact a gulag. The gulag is a Soviet concentration camp, a camp in which under an atheistic ideology, in which there is no rule of law at all. That is not so. Governor Phillip came with a charter of justice. He didn't come with any lawyers, perhaps that was a good thing, but he did come with a set of law books. And there was a judge advocate appointed, a man who was not a lawyer, but being a sensible, intelligent man, very capable of applying the laws. Anybody can. Remember the case I told you of Henry Cable and Susan Holmes? The young lady and the young man who'd met together in prison, they'd had a baby, and Lord Sydney had been crucial in making sure that the baby came to Sydney too. Philip gave 5 couples permission to marry, and they were married on the 10th of February, very soon after the arrival in Sydney. And then they looked to gather their precious goods. Remember, they had all that money. They bought some valuable goods, goods which we today would think is of no importance, but which were very valuable in those days. They had this substantial package. When they went to they had somebody, they asked the Reverend Johnson to go to the ship. When he went to see the captain said, well, most of them are lost, all I've got are just a few books, but they can have that. Well, Henry Cable was a persistent man. Although he was a convict, he went to the judge advocate, David Collins. David Collins, that very same day, it was the 1st of July, issued an order for the captain to be brought before him, to be brought before an informal court in Sydney. They worked very quickly those days because the captain was brought before the judge the very next day. And the judge heard evidence. He heard the evidence of sailors. The captain said, but these convicts can't sue me, because under the law of England, as it then was, a convict could not sue. They lost their legal rights. The judge advocate said, well, I don't know that they're convicts. You must prove to the satisfaction of this court that they are in fact convicts. Well, it was of course obvious that they were convicts. And the captain said, well, there are no doubt documents which can prove this. And it then transpired from the authorities that all of the documents relating to each of the convicts were still in England. There were no documents. The court then ruled that there was no proof that these were in fact convicts. There was no reason why the case should not proceed. The judge then heard the evidence of the sailors about where the goods were, heard the evidence from the captain and from Cable and Susanna Holmes, and decided that the captain was lying. Obviously had stolen the goods, and therefore he ordered the restitution of the goods. He gave a restitution in money. It was the very first example in New South Wales, in Australia, of the application of the law. In fact, you can read the case. I actually went and found the case, and it's in Cable and Sinclair in 1788, New South Wales King's Report at page 7. It's actually there. It's the very first civil case in New South Wales. Would this happen in a Russian gulag? If you had a complaint with a Soviet official, do you think you could go to a magistrate and get an order against an official? Of course you couldn't. The same in the Nazi criminal camps. We had the rule of law in this country from the very beginning. It was a Christian rule of law. Philip also brought the English language. And it was an English language which had as its greatest formative text the works of Shakespeare, imbued with Christianity, the Book of Common Prayer, which was Cranmer's translation and Protestantization of the Roman Missal. And there was then also the King James Bible, which is a remarkable book of glittering majesty, which has made so much of the English language. All of the formative works in relation to our language are Christian. And of course, they also brought our Judeo-Christian values. That had a reflection 1 century later when the colonies voluntarily decided to unite. Because when the draft of the Federal Constitution was sent to the people, remember this was the very first constitution in the world where the people themselves were called on to vote and approve the Constitution. When the Constitution went to the people, there were more supporting petitions concerning a proposal to put in the preamble these words, which reflect our Judeo-Christian values. One delegate called it to ensure that the invisible hand of providence was reflected in the Constitution. This was that part of the preamble which says, whereas the people, humbly relying on the blessings of Almighty God, have agreed to unite in an indissoluble federal commonwealth under the Crown and under the Constitution. Those words, humbly relying on the blessings of Almighty God, were thought to be the most crucial from the public point of view, that this should be a federation under God, something you don't find in the Constitution of the United States. You find it in the Declaration of Independence, but not in the Constitution itself. This led to another clause being put in the Constitution that there be no establishment of religion. It's fortunate indeed that the judges of the High Court of Australia have been more restrained than those of the United States in relation to a similar provision in the United States, that is, that the federation in the United States not establish a church. The judges have imagined rules which stop prayers in public places, which stop the indication of Christianity in public places. This is a reading into the Constitution, something which the Founding Fathers never intended. Fortunately, our judges have never done that. And the final institution Philip brought to Australia was the Crown, which became eventually the Australian Crown. And it is an intensely Christian institution. The Queen, as you know, is not only crowned, she is anointed. I think she is the last sovereign in the world to be anointed, following the tradition established with the Jewish kings in the Old Testament. She swears oaths and she receives communion, and in 2000 she said this: "For me, the teachings of Christ and my own personal accountability before God provide a framework in which I try to lead my life." There's much truth in the saying, where there's a crown, there's an altar. Well then, what are the consequences for Australia? Australia has continued as a country imbued with and living under those Judeo-Christian values.